So are you saying that you could tell someone they're ugly every day?
You could tell somebody they're ugly every day if they're inclined to do so, Paul, and there would be no legal repercussions as long as it doesn't fall within a protected characteristic. Senior directors, business owners who have a lot of trouble when it comes to letting somebody go. It is absolutely hitting the foundation of the economy and the businesses, and it's going to flood the tribunal system. But after 2 years, you can quit your job and you can claim something called constructive dismissal, which at the moment is capped at about 118 grand. If they're going to bring a claim, they should realise that this is a serious system and there are consequences if you're going to do it without any merit.
Before we get into today's topics, it'd be a great help for the channel if you could hit the thumbs up, like, subscribe, or hit the notification bell. It's easy and free to do, and it's a great help to the channel. Now let's get on with today's show. Welcome to another episode of Is That Legal with me, Paul Britton, solicitor from Britton and Time Solicitors. We've got a great topic today, a topic that affects most of our lives, employment law. And I'm joined by a top employment lawyer.
My name is Tosh Polpitiye. I run an employment law solicitor firm called Astute Law Limited. I've been a solicitor for over 2.5 decades now. That sounds old, doesn't it? And we deal with right across the board with all sorts of employment situations, employers and employee problems, pretty much dramas in the workplace. Might result in a six-figure settlement sum in some cases for employees. In other situations, just getting rid of a nightmare employee who has been causing problems for ages and you don't know how to resolve the situation. So that's us.
Great. Well, I mean, six-figure settlement sums, I think for any employee listening, their ears are probably perked up now. Any employer is probably like, what? That's a lot to settle for.
It was a unique situation. That particular one was a high-profile sexual harassment case.
Okay.
So they're not always that sort of thing, but typically people will get somewhere between 6 to 12 months' pay as a sort of a payoff if we get a settlement, and the majority of the cases get settled.
Good cases to get in.
Because compromise is the best lawyer, isn't it?
Yeah. Or if you can avoid going to the employment tribunal, then all the clients are happy, aren't they?
Yes, that's right.
So how's your morning shaped up today?
Well, I mean, this is the highlights, Paul. As I said to you, coming here, I was looking forward to the podcast, quite excited about it. Very professional, lovely setup.
Good.
This morning I did a networking meeting, which is where we met.
There we did.
B&I.
Over a year ago.
B&I Mayfair, correct. And, we meet up every single morning to look at business opportunities, how you can help each other. So that's quite fun. Not necessarily getting up so early is fun, but it's quite fun doing that. And the rest of the day is fairly light today.
And I guess so it's there, so you're looking for like employer clients, employee clients, or just referrals?
Yeah, and when I go there, I mean, typically we help a lot of employees get out of nightmare situations. Employers is the real sort of bread and butter stuff because they are the ones that have repeat problems. Staffing issues, what do you do with that person? How do we get that person to step up? How do we get them to step out? Whatever the circumstances are, typically things like when they're off sick for a long period of time, how do you handle the situations effectively, lawfully? But more importantly, actually, they don't really need employment lawyers. That's a really weird thing coming out of my mouth. What they need is a really great problem solver, and I think that's the case with whatever we do.
It is.
They just want someone who's going to solve the problem, not to dictate the law and read out of a textbook.
And in a cost-effective way.
Correct. They want someone who's kind of, I think, has been doing the job long enough that you've kind of rolled your sleeves up, you're up in the trenches, so you know what it's like on the ground rather than some sort of academic approach. They want it. They want practical solutions.
Common sense.
Yeah, absolutely. It really is. It really is.
Because sometimes when you're very close to a case, it's very difficult to see the wood through the trees.
Yeah, absolutely.
And you just help bring sometimes that objectivity to a business owner to get them out of a sticky situation.
It's also basics, Paul. Things like what to do, what to say, how
when
to say it. Yeah, because
timing.
All the information is out there on the internet, isn't it? You just need someone to piece it together to put it in a way that's actually effective rather than just regurgitating it. So a lot of it really is what to do and what to say, and you'd be surprised. There's some high level senior directors, business owners who have a lot of trouble when it comes to letting somebody go. It's a confrontational situation. So again, it's not the way you have to present the situation to them. It's not their fault they're in the situation. That employee has potentially put them in that situation. So we need to get this sort of psychology right and the language right. That's the majority of the work, actually, getting it done in the right way.
People often say to me, when is the best time to come to an employment lawyer? And I always say, well, as soon as there is a sign, even a sniff of trouble.
Yeah, absolutely.
Because they'll just wade into it, won't they?
It's the foundation, isn't it? If you get the root, if you get there early enough, you can then create the situation or put it in the right direction where we're looking for the outcome that is required for it, the right direction. Even if it's opening up a can of worms, at least you've opened those can of worms early, and then you're able to deal with, you know what you're dealing with. You're dealing with liability or no liability. A lot of the problems you have when employees raise these sorts of situations is they bring up rights that they think they have, but they don't really have them.
No.
So it's more led by a moral compass of what they think is right and wrong rather than what the law is dictating about it.
Yeah.
So what often needs is an employee needs somebody like us to be able to actually, no, that's not right. And people talk a lot about employee rights, but actually employers also have a lot of rights. They're just not in the law, but they've got the right for the employee to work for them and do certain things. And and so when they often feel they're on the back foot. So it's just giving that an empowerment, I think.
Yeah. So when we talk about employees, we talk a lot about employees, but there's a lot of different hats that individuals can wear within the employment law legal framework.
Yep.
So we've got things like volunteers, contractors, employees. Let's start with employees.
Yep. There are the three main categories.
How do I know if I'm an employee?
Yeah, you're absolutely. There's three main categories, and if you're an employee, you have lots of employment rights, obviously. If you are self-employed, you don't have any of those employment rights.
Okay.
And the third category is a worker, which means some rights you have and some you don't have. So there's three minimum requirements to be regarded as an employee. The first thing is control. And we talked about it a bit earlier, the master-servant language was the old law, so they talk about, but control. You've got to do what I say as you're my employee. I'll tell you what to do, when to do it, how to do it, and all those sorts of things. So you've got the control over it. And obviously, you'll be penalised if you're not doing it the way you're supposed to be doing it. The second thing is a mutuality of obligation, which in English means I have to give you work, and you've got to take it. Can't say no. So a self-employed person can say no to certain types of work. And the third thing is personal service. So personal service means they've got to provide that work. They've got to provide that employment relationship. They can't get their mother, their brother, their mate to do it. Whereas with a self-employed person, there's typically a substitute clause. So, for example, none of my clients could ever consider me their employee. If I'm not available, one of my other lawyers will step in as a substitute to do the work or do whatever's necessary. So those three things are required. And
For an employee.
For an employee, yes.
But then if I'm allowed to substitute my service, I'm moving into contractor work.
Correct.
Yeah.
Correct.
Okay.
Typically, the way I always advise clients, if it walks like a duck and it quacks like a duck, it's a duck.
Okay.
So whatever you label it is whatever you want to label it, but the court is not going to just look at.
Don't call it a cat.
Yes, exactly.
It's still a duck.
You got it. So that is the reality of it. It's not that complicated. It becomes complicated when people are trying to try something on.
And do you come across that ever?
Yes, we do. And I mean, people. There's a lot of benefits for individuals to regard themselves as self-employed. Tax benefits. They get paid better. They have more freedom of certain situations. But in reality, when you start digging deeper and they see that they are working the same hours every single week and they're not working for other people and they're only working for that person, they do have to ask for holidays, then it starts to stack up. And the reality is there's not one thing that will determine it. So if you have an employee that's invoicing for their services, that won't suddenly make them self-employed. No. It's going to be a plethora of different things ticks up. So that's control, that's mutuality of obligation, that's those things. Okay, is this person business on their own account? Do they get paid for holidays? So it's a numbers game. And whatever looks like it's more of is what it then will lean towards on a balance of probabilities.
And is tax a big facet?
It's one factor, but not massively so. And strangely, the way that the HMRC view employee status and employment lawyers look at employment law are slightly different. I won't go into it too much.
No.
But typically speaking, it's going to be the way they operate.
So if an employee says, I'm definitely an employee because my employer pays my tax and national insurance contributions, that's not a done deal.
It's not a done deal, but it typically is the other way around. So typically you're not going to pay the tax and national insurance for somebody who's self-employed, so it would be an employee. So it's where the person is saying, well, I'm an employee, and then the argument is, well, hang on a minute, you paid your tax and you paid your national insurance, you do those things.
And you do a self-assessment every year.
Correct, you do all those things.
That's working against them.
That's working against them, but one factor, but there might be 100 other factors that say it's an employee. He's at the Christmas do, he works with the other staff. If anybody comes in, you can't tell the difference between him and an employee. He does the same work, he's just paid differently. So it's going to be what's more likely than not.
Like having the right to apply for annual leave and be paid.
Correct.
Right to raise a grievance under the grievance policy.
Yes, all those
or
things.
Be subject to a disciplinary under the disciplinary policy.
That's right.
Okay, so you look at all these factors, weigh it up.
Yes.
And then we've got volunteers. How do volunteers look? Is that a worker? Is that?
Yeah, so volunteers are not really, they're not paid, so that's fine. They're often covered, expenses are covered.
Yeah.
There might be situations where they would regard the expenses as being paid, but in reality, I wouldn't look at volunteers as a high level or primary sort of case we get. We do get a lot of workers. So workers are people that can decide when they do or don't want to work. It's often referred to as bank workers or bank staff. And that means they can decide when they work, when they don't work. It also means they accrue holiday. So that's a slightly strange factor, but they can't claim unfair dismissal. They can't claim other things in the employment tribunal. But there's some changes in the law that are coming up in next year, which we'll be talking about shortly.
Well, tell us.
Well, so for
You've
example,
done it now. You've opened Pandora's box.
So come April 26, there is an agency called the Fair Workers Agency, and they are going to be appointed to be able to help people bring claims in the employment tribunal.
Has this been set up by the government?
Correct, yes.
A free service?
Correct.
Like ACAS?
Yes, correct.
Okay, go on.
So the idea is that people will get access to the help that they need to be able to present claims, and I think that's quite a big game changer because some people cannot afford legal representation, and there is now a service there that will support them to try and get certain claims, holiday pay, money claimed, whatnot.
What's the thinking behind that? Is it just... Do you know what the thinking is?
The thinking behind it is just to ensure that there's more access to proper legal support that isn't necessarily the Citizens Advice Bureau or the local law centre, and there's more accessibility, more resources, and more ability to be able to deal with what's going to inevitably a high volume of claims that are coming in because of other changes that are coming in.
So and to dispose of them in their nascent state rather than burdening the tribunals.
That's the idea.
Yeah, the end goal at the very end
correct.
is...
But, ACAS is still there to do that purpose. These guys are there to help as if they were representatives to go through that and also take it to tribunal if necessary.
Okay.
So there's more resources available to employees.
But this isn't in place yet?
Not till April next year.
Do we know what the process will be? Do you go to ACAS first and they refer you to them, or is that all?
We don't know.
We don't know yet. Okay.
Yeah, it's still a bill in place, but it's due to come into place, so we don't have the details.
So this is our April episode.
Yes, correct.
That will deal with.
I'll be there.
That will narrow down on these issues of how individuals can claim on this service.
There's other big changes happening next year, which will result in a big influx of work, I imagine.
Yeah.
For example, the tribunal limitation period at the moment to bring a claim. So how long you've got to bring it is 3 months minus a day.
Yeah.
They're going to extend that to 6 months. So there's more time for people to bring claims.
Well, that's a step back, isn't it? Because wasn't there a rule back in the day where it was, unfair dismissal claims 3 months, but discrimination 6 months?
No,
there was a hybrid system.
So they were all 3 months.
Yeah. Back.
Well, a lot further back, yes.
In the decades, like under David Cameron's government, I'm sure it was 3 months for something like contractual unfair dismissal.
Yeah.
But if it was discrimination, you got 6 months.
Yes.
And then someone along the line changed it all to 3 months, less than 1 day.
Yeah, we're going backwards on a few things. They're doing day one employment rights, so to claim unfair dismissal. So day one unfair dismissal rights means that the minute they walk in, if you don't go through a proper process, and there is a get out clause as long as you've got a proper probationary period, you could fire them within the probationary period. That's typically 3 to 6 months, but you've got to now have a proper system in place. But
how long can you extend the probation period for?
So again, we don't know yet. Realistically, if it's going to be anything beyond 6 months, which would be normal.
If it's not dealt with in the statute, then it's going to come out of case law at some point.
Correct. That's exactly right.
Was that proportionate?
Right. Yes, and that's exactly right. So the problem we have in the old days, I don't know if you remember, unfair dismissal claims could be brought with somebody who had 1 year service. It's presently 2 years. And do you know why they stopped that?
Well, the Conservatives moved that up to 2 years because they said that employers needed more time to assess an employee's ability, particularly in large organisations where you disappeared into the background, and a year wasn't enough.
They did that, and the other reason was it broke the system. Tribunal's going to handle it. There were just too many claims that were coming in.
Well, I don't know about you, but I'm getting cases listed in 2027.
Yeah, that's right. It's a lot.
Yeah.
And in fact, ACAS has broken at the moment. Anybody doesn't know who ACAS is? ACAS is a government organisation designed to help workplace disputes so they don't end up in tribunal.
And you have to go to ACAS.
You have to go to ACAS. There's it's called an early conciliation. And you go to the ACAS early conciliation process. It's a 6-week process to try and resolve it so it doesn't go to an employment tribunal. But they are also broken. They're just completely overwhelmed with the amount. I'm submitting claims through ACAS right now. They're getting in touch with me in week 6. It's too late by then.
So what do? Just issue the certificate?
They issue the certificate, yeah. So then you're
they actually just do that?
That's right, yeah. They have to just do that because the time is the time. So if they haven't got time to get back to us, they haven't got time to get back to us. I've got one for a case just this week. I haven't had a chance to even speak to them. We've got the certificate.
What
in.
pointless service then?
I mean, they're speaking to somebody, I presume. It's just not necessarily us on this particular occasion.
Okay.
But what I'm saying is that day one rule will go only so far, because it is absolutely hitting the foundation of the economy and the businesses if they're going to do it that way, and it's going to flood the tribunal system. It'll be too much to handle. Is what I predict.
What do you think will happen when they bring in these? I mean, if they're bringing in new rules, new laws, isn't that just going to? I mean, in criminal defence, for example, when they pass new laws, new crimes, criminal defence lawyers love it because it's going to be more work. More people are going to fall foul. In employment, in a system that's already overwhelmed, burdened with cases, if they bring in more rules, how do you think that's going to impact on ACAS, this new service that's coming in April, as well as I mean, you haven't said it, but I assume the employment tribunals are overwhelmed as well.
Yep. You're completely right. Where's it going? Floodgates are opening on an already overwhelmed system. They will have to pull back and put limitation periods back in place. So unfortunately, whilst that means there'll be less people being able to pursue rights and claims for certain things.
When?
I don't know. I'm predicting it. I don't know when. Last time they reduced it to a year, and I believe, you might be able to correct me on this, Paul, I believe that was the position for about 2 years. And then they just said, look, it's enough.
Yeah.
And then they put it back to 2 years.
Okay.
And so, at the moment, that does mean that employers can get rid of any employee within 2 years, as long as there's no discrimination elements or anything like that.
Yeah.
So I understand that. They also, a lot of people don't realise there isn't any anti-bullying law as such. So an employer could bully an employee for the first 2 years and
bully
not be
them
able
out.
to make a claim. Yep, as long as it's not discrimination. But after 2 years, you can quit your job and you can claim something called constructive dismissal. So there's no claim for bullying by itself. There's no claim for harassment and those things, for race, sex, religion, those sorts of things. But there's no so all of these things are bills that are coming into place now to protect the workplace and the employees and all those things. How that will have practical application is going to be tricky. Because, this isn't supposed to be the thought police.
No.
It is supposed to be the behavioural police, I suppose. Let's get people conducting themselves in a certain way. But I don't think they've gone about it in a way that's practical.
And does it ultimately promote business or does it fetter business?
I mean, employers are now going to have to do things through the hilt. I'm saying certain things I agree they should do.
Yeah.
You need to have certain things in place and processes, but the day one rights I don't agree with. I think an employee should acquire that right.
But the carve-out is that probation period.
Correct. The carve-out is that probation period.
But we're saying 6 months.
We're saying 6 months. We don't know yet. And you're right. The first thing as a lawyer I would be doing to protect my employer clients is how far can we extend that for? And I suppose the justification will be, well, how long has it taken to figure out that this person's good or not good?
I mean, I guess if you put in very good, rigorous key performance indicators during a probation period.
Yep.
I mean, these things, they're great in concept.
Yep.
But the management time that they take up to roll out, that's a different question.
Yeah,
but
absolutely right.
If you had really good KPIs that were measurable and then the employee failed to hit those, as an employer, your decision would be let them go. And 6 months doesn't seem fair to get someone up to speed from where I'm sitting. So then you are stuck with let them go or extend it. But if you extend it, how long do you extend it for? Another 6 months? And run the risk of being told you're abusing the extension process?
I suppose it depends on what the nature of the job is. If you're looking at a sort of apprenticeship sort of thing where they don't know nothing, I'll say. If they're going from zero to hero, sure, it's going to be a longer process, right? Although
they know everything when they're an apprentice.
We all did.
They come in.
So
The fonts of all knowledge.
I think 3 to 6 months is a typical, you're getting a certain level of skill. If you hire a new lawyer involved, depends on what PQE they have. So it's going to be relative. It's going to be fact sensitive, relative to the circumstances.
Okay, and you touched slightly on on bullying in the workplace, and you could bring, if you've got your 2 years, you could then bring in a constructive unfair dismissal claim.
Yes.
Is there any legislation in particular you could put your finger on that protects people from being bullied now, or is it in the pipeline?
So if there is bullying because of what's called a protected characteristic,
yeah,
there's 9 of them. Don't ask me to name all 9.
Oh
go.
God,
Race, sex, religion, gender reassignment, marital status, disability, that sort of stuff, right?
You got there, yeah.
Yeah, got mostly there. Sexual orientation.
We'll add a little section on the clip below in the description to cover all of those 9.
So there are 9. Anybody can Google them.
Okay.
And if you're being bullied because of those things, you don't need 2 years service.
No.
You can day one. In fact, you don't even need to be employed. So if you demonstrate that sort of behaviour at the interview, for example, they can make a claim. Those claims are something called injury to feelings, and they're worth up to about 60 grand at the moment. Certain circumstances, they're unlimited, but there's no point talking about that right now. But typically up to 60 grand. If it's just bullying because I don't like you, if I'm bullying my employee because I don't like them, nothing to do with protected characteristic, there's no protection in place at all for the first 2 years.
When we talk about bullying, are we talking physical or?
No, I mean, physical.
You can't hit someone and
No, you can't start slapping your stuff around.
No.
That would be criminal. But there's nothing in employment law that protects you.
Like being fat is not a protected characteristic.
Unless, of course, it's a disability. So if you have if you're a disability and the disability condition is an eating disorder of some kind, then yes.
And it impacts your day-to-day life.
Correct. Normal day-to-day activities.
Yeah.
So disability doesn't need to be a wheelchair.
Okay, ugly.
Yeah, you can dismiss somebody.
I'm just trying to get a good example for our listeners and viewers.
Them because they're not easy on the eyes. Absolutely.
Yeah. So
that's not a protected characteristic, unless, of course, it's a disfigurement and it's a disability again. Is it a protected characteristic?
But you could bully someone, and so you're saying that you could tell someone they're ugly every day.
You could tell somebody they're ugly every day if they're inclined to do so, Paul, and there would be no legal repercussions as long as it doesn't fall within a protected characteristic.
Right.
So there's no claim for bullying by itself. After 2 years, I'm just bullying somebody because they don't like them.
Yeah.
They can quit their job and claim constructive dismissal, and they can claim up to 1 year's pay, which at the moment is capped at about 118 grand, 18.5 grand.
Changes every April.
Yeah, correct. But
goes up a little bit.
One of the things what this doesn't change, whatever the laws are, is the consequences in terms of the liabilities and how those things are dealt with. So you and I have spoken about this before, and we mentioned it earlier in the podcast. Nobody wants a lawyer; they just want a good problem solver. So the way I look at these things is there's no law that says you can and can't do something. Every law just says there's a consequence for doing something, right? There's no law that says you can't break the speed limit. It says you break the speed limit, you get penalty points or fine, and I'll put my hand up to that.
So you can, but you're going to get.
So the question is now, what are the consequences? So it's good to know that, because if you look at so let's say I have a client that has an employee that's been there for 20 years, absolute nightmare. They've not done any processes, no procedures, whatnot, and they said, "Tosh, we've had enough."
Wait, slow down. So an employee, you've had them for 20 years.
Yep.
And they've become a nightmare. They haven't been a nightmare for 20 years.
Maybe they've been a nightmare, but maybe they've been the top earner, or maybe they let things slide for whatever reason, but it's just now got out of hand, and now they want to deal with it.
Because they bring in the money.
Yeah, for whatever reason. Yeah, that's right. Or they didn't want the confrontation. They didn't want the hassle with the situation.
And they let it run for 20 years.
I'm making the scenario, but it's not.
Go on, yeah. I know.
It's not uncommon that it's 10 years, for example.
Okay.
So let's say that they've got a length of service and they now want to get rid of them. Well, the first thing to look at is what's the consequences of getting rid of them. Not step one, verbal warning, first written warning, final written warning, and so forth. I'm not saying you have to go down that route, but if we're going to give any kind of service to our clients, they've got to know what their options are. You can follow the textbook route, or you can follow a shortcut. And actually, there's a nice way to fire people, believe it or not. So the approach that I look at is if you want to get rid of somebody, they're entitled to their annual salary, so up to 1 year's pay, but it's subject to their ability to get another job. That's the key part of that sentence in the liability. Subject to their ability to get another job. So before we even start the process, what do you think we do?
Tell me.
We get a recruitment agent and we get them another job. How long will it take this person? Here's the CV. Here's what their skills are. This is what they've been doing with us. It doesn't have to be unpleasant. Sometimes things just don't work out.
Yeah.
So it doesn't have to get very personal, which often happens. And you know what? You and John, whoever's talking to John, John knows the writings on the wall. It's not been working out for a long time. It's a welcome way to respectfully part ways. It doesn't have to be anything that's not done in a dignified manner. And you can agree terms for those departure, right? References, so nobody's looking over their shoulder. And you walk them into another job. Here's the recruitment agent. Get in touch with them. It also minimises the liability. So you know what we'll do, John? We'll give you a 2 months pay, because that's how long it's going to take you to get another job. We're going to give you a good reference anyway. So that you bridge the gap. And if you went to a tribunal, that's all you're going to get anyway, your ability to get another job. So a lot of it is just to how you say things. I mentioned this right at the beginning. How you say, what to say. And in an employee's point of view, it might be, well, I know my rights and I'm entitled, and you can't do this to me. And it becomes very emotive. They're thinking about the mortgage, kids, whatever expenses they've got. Well, if you just address that quite sensibly, and they don't do it in the first meeting, but maybe the second or third, they start to see the way of it going. So you can fire people nicely. So my point here is, whatever the laws or the scaremongering that's going out there, the solutions aren't different. There's still ways to get around it. I don't mean to get away with discrimination or with unfair dismissals. I'm saying there's a way to have a solution that meets both parties' needs. And there's another change in the law that's coming up that I absolutely hate.
Before we continue this episode, a word from our sponsor. This episode of Is That Legal is proudly sponsored by Oliver Lorenz Studios, your on-demand design team for B2B service providers. They're your dedicated design partner, delivering consistent, high-quality creative without the overhead of hiring in-house. Think bold branding, polished presentation, and visual content that actually moves the needle? Check them out at oliverlorenstudio.com. Design support just when you need it.
Changing the law that's coming up that I absolutely hate to do with settlement agreements. Have you heard of that one?
No, tell us.
So what they will have is you can, the normal thing there is something called a non-derogatory clause in there. Non-slagging off, as I like to call it.
Can't denigrate the employer on your social media and say it was such an awful place to work.
Correct. You can't say anything negative about each other. Everybody just walks away and start. Let's just move on our just separate paths, and that's it. What the new settlement, the laws that are coming in again, this is next year, is that they are looking at removing the ability of the employee being gagged. So you have a settlement agreement, but you can't stop them talking about what happened in the circumstances of their departure. Well, no employer is going to want to go for that.
No.
Why? The whole point is to just keep it stum. Yeah. Not because there's something to hide necessarily, but sometimes employers raise something about discrimination. It's got no legs, but at the same time, we've settled it because it's just a commercial reality to just get rid of the problem.
Well, commercial is always an important one because not all are going to be paid the same.
Yeah.
And so if they start talking about what they got...
Well, they're not allowed to talk about what they've got. They're allowed to talk about the circumstances of their departure.
Circumstances.
You know what? I got a deal, but I was discriminated against, I was harassed, etc., etc. None of that may be true, but that's the circumstances around it. They're allowed to.
But then if it's
sing
not
like
true,
a canary.
But if it's not true, so if they say these things on socials and they're not true, then we are looking at a different type of claim by the employer.
Yes, but it also means why settle the case?
Yeah.
If they're going to be allowed to come and say things about it already, why bother settling the case? Exactly. They don't want, the point of these things is let's just move on. We've got a disagreement about what the circumstances were. Let's move on. But if they're going to be singing like a canary, as I say.
Well, what does move on look like? You're fired.
Move on should be the way it is presently.
Yeah.
So there's an agreement that it says this, you're leaving that for money.
But under the new rules where they can talk about it, so the employers aren't taking it anymore, what does move on look like?
Now it looks like exactly before, except
you're just fired.
Except the employee can say everything that happened regarding the circumstances.
But you're saying that employers will not take that when that comes out.
There's no reason to do that because.
So what's the alternative then? Let's fast forward in time. That's now in place.
It's going to be tribunal claims.
So the employer will sack them.
They sack them, and there won't be a settlement talk because the employee can discuss all the things that they want to keep confidential. And then what will happen is the employee has to bring it to a tribunal.
And prove it.
And it won't be settled.
And they have to prove it.
Correct, yes.
And a judge will have to make a finding of fact that you were discriminated against.
Yes.
Or you lose your case, and then you're done.
Correct. So it's forcing everybody down, more likely than not, a path where you're forced to go to a court case, spend anywhere between 20 and 50 grand when something can be resolved very easily at the beginning. But because there's no confidentiality, no NDAs as such, then people's choices are becoming less.
Makes me wonder how are they going to fund that sort of system?
Yeah, I agree. I think the government has just thought about things that sound really good for employees and not really considered, I don't know how they could have considered what the practical applications are on ground level.
They get you in.
Yep.
Okay. And so that's all employee rights. Contractors, they have no rights because it's just
No,
it's just business.
Correct. Just like us, we're in business on our own account. If someone wants to treat me badly, I mean, what am I going to do about it? I'll stop working with them.
Yeah.
As long as there's nothing criminal, or there's no contractual breach of some sort.
No.
Apart from that, there's nothing. Okay. And workers would have holiday rights. I was mentioning they have certain rights there.
Do volunteers have holiday rights?
So they're volunteers, so they have no obligation. There's no mutuality of obligation pool. They have no obligation to work. They have no obligation to be provided with the work. So that means they don't have to they can take holidays when they feel like it, is what they're saying. They can pretty much tell the employer when they want to take the holidays. I mean, you would do that as a courtesy anyway. But there's no claims to be had. There's no financial liability as a result.
Just for anyone that's heard us talking about ACAS, is there anything else we can drill into on ACAS so that someone might be sitting there now saying, this is great, I want to go to ACAS, and they're looking for, how do I do that? First of all, how?
So you Google them, you contact...
Or ChatGPT.
Yeah, ChatGPT. You Google ACAS, and there'll be a number there, and there'll be a form to fill in. It's called if you're doing the pre-tribunal claim, it's an ACAS early conciliation notification form, bit of a mouthful.
Yeah.
If it's not, it's just to resolve the workplace dispute. You can just contact them anyway.
If you're employed.
Yeah, if you're employed.
You can
it goes both ways. Employers and employees can use them to help resolve workplace disputes. That can include them coming in as a mediator. So let's crack some skulls together and figure out what the problem here is, get it resolved that way. Internally, or it's going to tribunal. And so before it goes to tribunal, we try and do it, but it's done through the phone, through emails, that sort of way. But their job is there to try and resolve that dispute in whatever way that means.
So let's say termination has happened, they're no longer employed, they go onto the ACAS website, they fill out a notification of early conciliation.
Yes.
That goes to ACAS
Yep.
and to the employer?
So ACAS first, there's a conciliator that's appointed. And one of the questions on there is, do you want to go to the employer first? So do you want us to talk to the employer first or talk to you first? So it depends what you tick.
You tick me, no?
I typically say talk to me first, so I can put a context in there and then get them to talk to the employer. But they have a choice.
And then 6 weeks is burnt out.
6 weeks burns out. It's not resolved by then with a COT3 settlement is what it's called.
Yeah.
Then you get a certificate. You need that certificate number to lodge an employment tribunal claim. And you've got 1 month from when you get that certificate to lodge that claim. If you miss those deadlines, it's out of time.
You're stuffed.
Yeah, you're stuffed.
And if someone has missed that deadline?
Then they're out of time. There's no jurisdiction.
Okay. But can they still bring a claim out of time?
So they're very rare circumstances.
Yeah.
Ignorance of the law is not a defence.
No.
So if that person was in a coma and unable to go and present the claim or do anything like that, that might be something, some sort of medical scenario. Other than that, I can't think of one.
But the employment tribunal has discretion on whether to let cases in on a case-by-case basis.
It is a discretion, but for things like time limits, they're quite strict.
Yeah.
As I say, ignorance of the law is not a defence to it. So there's got to be some really good reasons for not being able to present a claim in the tribunal.
Okay. And then if you're volunteering, so am I right that if you're volunteering, that means you're not getting paid, and it's kind of, is it an old-fashioned work experience where you just give up 2 weeks for free? How long can it go on for?
What kind of work experience do you mean?
So if someone said to me, I want to come and do some work experience in your law firm.
Got it. Yep.
I mean, and volunteer.
Yep.
Are there any restrictions on me as an employer?
No, not really. I mean, there are age restrictions. You can't have a certain age under 15. There's different requirements, I suppose. But typically, work experience, you would have something in place to see what they're doing there.
Yeah.
What is the experience they're having? They've got to, if it's in a law firm, there's got to be some NDAs or some sort of confidentiality.
It can't go on for 2 years, surely. You can't have.
No.
Okay.
Typically, it's not going to be. Work experience won't be that.
Can you
work
imagine?
experience will be maximum would be a year, depending on what kind of person it is. Typically, it's a summer.
Okay.
Or a season.
Yeah.
So and again, they don't have rights as such, but they have the right to be protected, to have a safe place of working in a safe environment, and those sorts of things. So employers will have responsibilities like any other person walking into their offices.
So if they trip or fall.
You got it. All those things have got to be in place. But apart from that, no. Work experience is quite simple. It's whether you got the time to do something that will be worthwhile for them.
Yeah. And if you want to go to the employment tribunal, does it cost money?
Yes. So there are free options. There are different types of lawyers out there if you don't know. There are no-win, no-fee lawyers, which are still not free necessarily. They do an initial assessment fee to figure out whether the case is worth it. And other free lawyers might be Citizens Advice Bureau. There's the free representation unit which you can get through the Citizens Advice Bureau or Law Centre. But typically you're going to get lawyers, who, if they're not in those categories, who are either hourly rate or what we do is fixed prices. So fixed prices kind of works for us because you kind of get a certainty of an outcome for that fixed price. So they know exactly what they're getting. So those are the different types of scenarios that we have there.
And employment's running quite high at the moment in the UK. There's lots of people in jobs.
Yeah, I mean, it's. I would say that I think you gave me the stats regarding employment at the moment. What was it?
Someone might have. I think there's 75%.
Yeah, I mean that seems incredibly high.
Yeah.
I would have expected the stats to show a lot.
I'm not
lower.
sure where our researcher got that from.
Well, let's assume it's correct.
Yeah.
I was a bit surprised to see that stat because AI is out there now. Now, don't get me wrong; they're not going to replace humans in the entirety just yet. But for certainly, employment lawyers using AI will replace the employment lawyers that aren't. So it is an edge that helps. So I was quite surprised to see that that isn't a factor in here in some way or another. But if that's the stats, that's the stats.
Are you seeing more clients, both sides, using AI before they come to you?
Yes, a lot, and it's dangerous. Because they are using it to do pleadings, to do all sorts of things. There was a case that was high profile, I can't remember what it was in the news, where there was a lawyer that used it in court. And unfortunately, AI came up with cases that didn't exist. So he didn't, it's all well and good using it. So for example, I might use it, and I would say that whatever prompts I use, 90% of it will be accurate. But obviously you need that specialist brain to know what the 10% is to fill the gap. So if you're just going to blindly follow it and just brain dump into it, I mean, good luck, but that's not going to work, and that's going to become a problem.
fact check it.
Exactly right. Exactly
Yeah.
right. So lots of employees are doing it. Yeah,
It does the heavy work.
Yep. Correct.
Yeah, I had a consultation the other day, and we were going through the claim, and then the employee looked at me and said, "What about my aggravated damages?" We've been on this call for about 45 minutes now.
Yeah.
And I said, "Right, okay, what do you mean your aggravated damages?" And he was like, "Well, what about my aggravated damages?" I said, "But what makes you think that you're entitled to nothing you've told me gives rise to aggravated damages." And you could see the life was like dripping out of his face.
Yeah.
And he said, "That's what ChatGPT told me."
Yes, of course it was.
I said, "Okay." I said, "Look, AI is a great thing, but whatever it tells you, if you've not come across that word before and you don't understand its meaning, you've got to say to it, what do you mean by aggravated damages?
Yes, at least find out, yes.
Yeah,
correct.
or how does that relate to my case?"
I don't know how the tribunals systems are going to deal with it, because obviously it's going to become more and more obvious that they're using ChatGPT. I mean, lawyers not so much. I mean, it's certainly not any lawyers that are worth their salt. You can use ChatGPT to make things a little bit better.
Do the heavy work.
Yeah, exactly right. But you're still going to need to tweak things, and you either have that know-how or you don't.
Yeah.
But how they will handle lots of employees bringing all sorts of claims with no substance, because obviously somebody's still got to go through those claims. Somebody's still got to look at that evidence. So it's going to be very time consuming. I wonder whether that's going to become more of a thing for costs awards against employees, which are very rare in the employment tribunal. Typically, there's only costs against. So in the high courts or whatnot, there are the loser pays the winner's costs. In employment law, each party bears their own costs, apart from when one of them is just being a nuisance. So either that means the respondent is defending the claim and they know that there's nothing to be defended, so they're being a nuisance, or the employee is bringing some sort of unmerited, frivolous claim against the employer. Well, you can imagine using ChatGPT, it's just going to be a lot of donkey work to go through things that perhaps don't have any substance. But if we can show that they've used ChatGPT to raise that rather than it being a genuine claim, then I imagine there'll be lots of costs awards that will start to increase.
And AI is only as good as what you put into it.
Correct.
The prompts that you put in.
Yes.
So if we're looking at cost awards, there used to be a cap as well in employment tribunals where you could only claim a certain amount, but now it's the discretion of the tribunal.
Correct.
So employees that abuse AI could end up on the receiving end.
Yeah, absolutely.
Of quite if they are just an irritant and an annoyance.
And it's right. It's right. It should be. They should have those things in place, because the tribunal system is free. So you don't have to have a lawyer to help you. You don't need to lodge legal fees to make a claim. There's no fee such there used to be. So anybody can bring a claim. So if you're so if they're going to bring a claim, they should realise that this is a serious system and there are consequences if you're going to do it without any merit.
Do you ever get involved in any jurisdictional disputes?
Not much. I presume you're talking like internationally, those sorts of things. So we only deal with the law of England and Wales.
Yeah.
So jurisdiction will normally mean things like time limits, those sorts of things, but otherwise abroad, not so much.
So if you're an employee, you've got an English employment contract, your employer is registered on Companies House in England, but they deploy you in New York City.
Yep.
And then, I mean, we know labour law in America is vastly different to what it is here.
Yep.
And then they sack you on the spot, which they do in the States.
Yes.
What does that employee do?
That employee will sue the English company
here,
who they have an English contract with. That's what the terms are covered by.
Yeah.
Law of England and Wales, and depending on the circumstances of why they've been placed abroad at that place,
deployed.
Then yes, they would sue the UK arm.
Yeah.
They could sue the UK arm. They would have the right to do that.
And would it matter if they were being paid in US dollars and they were paying tax in the States? And if the position had moved away over, let's say, a decade from that employment contract that they signed in this jurisdiction in England and Wales, would the employer be able to have any argument to say, yeah, no, look, we pay tax over there, we pay them in US dollars? Would that change it?
Yeah, it's pretty much akin to what we discussed earlier about the employment status.
Yeah.
So, what are the level of factors that show this person is a UK employee?
Yeah.
And what are the factors that say, actually, no, it's not. It's just somebody that's abroad that they're just paying to go there and they're putting it under a label of a UK contract. So if it seems to be a sham, then you're absolutely right, Paul, and it's going to there's not going to be jurisdiction. I'm presuming the first port would be to argue that exact point.
In the preliminary hearing in an employment tribunal
right at the
here.
beginning, you would assess whether he's an employee or not, or in the UK. And if he is, then the case continues, and if he isn't, then it doesn't.
And the tribunal determine it has jurisdiction.
Yes, or not, as the case may be.
And it's great if the employer's here, because
Yes.
whatever decision the employment tribunal makes in this land
Yep.
will be able to be enforced on the employer.
Yep.
It's always a helpful way to come in.
The most popular is the wrong word. The most common types of claims that we have tend to be discrimination and harassment.
Yeah. It's amazing, isn't it?
Yeah, I'm surprised. To be
in
honest.
this day and age.
Correct. And it isn't necessarily because they have substance. So a lot of the race claims that we have do not actually have a lot of substance.
So is it a card?
Yeah, it is a card and also a perception. You know,
Yeah.
if you want to go around thinking in that sort of way that maybe something is being perceived as being racist towards you, then you're going to take it that way. So sometimes that's correct. You know, I might get somebody saying, look, I'm the only person of my ethnic minority in the firm, and they fired me. I said, so why did they fire you? Well, because of my poor performance. Well, then it's got nothing to do with your ethnicity. So there are those things, but what there is a lot of substance to in terms of discrimination and harassment is disability, surprisingly, and maternity.
Okay.
So people coming back from maternity leave or they're about to go on maternity leave or their rights during those periods, that's quite common. And it's just employers still learning what they should or shouldn't do or say when an employee goes off on maternity leave. Disability is the most surprising one because employers have an obligation to look at what's called reasonable adjustments, put things in place that will make them able to do their duties in the best way possible as anybody else could. But a lot of things are not looked at in that way because I think people look at disability being somebody in a wheelchair, having a blue badge or whatnot.
Yeah.
But the reality is it could be all sorts of things, and the more abstract or obscure it is, the less there seem to be looking at proper adjustments. It's quite simple. As soon as somebody comes forward to you with some sort of condition, the first thing you do is you get a medical report or something to find out what you can and can't do.
Is occupational health the right way to go?
I think so. Absolutely. You can get it from a GP depending on how complicated the condition is. But if it's something like dyslexia, you can get a GP report. You don't need to go occupational health.
Really, a GP can do?
That's perfectly well. You can even Google a lot of the stuff with something to do with dyslexia. And how about just talking to the employee? What things would you need in place for us to help you? They will say whatever they will say, Dragon software or whatnot.
Grammarly.
Yeah, Grammarly. You've got all those things.
I'm sure there's a load of AI
There must
stuff.
be loads of things that can help. And if there are loads of things that are required and we can't do it as an employer, you don't have to do it. You don't have to do everything possible.
So if it's too expensive?
Correct. If it's out there, it's the cost and the administrative resources of the organisation. So they look at all of those factors. So again, what's reasonable is, it's a lawyer's dream, that word. We'll sit there arguing that all day long. But in reality, it's not that difficult. It's what's justified in the circumstances. So if you can do it, then we'll do it. If you can't do it, you just have to explain why you can't. You're not doing it just to be difficult to that person.
Under the reasonable
But if you
adjustments.
fail to even consider it, then you're on the hook for what we talked about earlier with the injury to feelings, which can be up to 60 grand. So we've got a lot of disability discrimination claims.
Injury feelings comes under the Vento bans.
That's exactly right, yeah.
Yeah, which changes every year as well.
That's right, yeah, that's right.
And if I go into a consultation, I'm always like, what are the Vento bans
Yeah,
at the
yes.
moment?
They're roughly, at the moment, there's 3 bands, if anybody doesn't know, and they're called injury to feelings. And the Vento bans, Vento was a case. And the Vento bans determine how bad the discrimination is. So if it's like a one-off comment, you'll be in the lower band. Lower band's about £1,000 to about 12.5 grand, roughly. Middle band's about 12.5 to about 36 grand. And the top band's about 36 grand to about 60 grand. There are limited circumstances where there's unlimited compensation. Those are circumstances where the discrimination has been so bad that the person can't ever work again. So we're talking about like a psychiatric illness.
Okay.
It's very rare, but it happens.
Yeah.
But which band you're in is obviously dependent on the facts. So, what if there's a one-off comment made, whether it's racist or sexist or something, you're probably in the lower band. If it's something at like management level, you're looking at the top band and everything else is in the middle. It's a very rough way of sort of looking at it.
Okay. And if you're on a 0-hour contract, people talk about 0-hour contracts. Can you still have a 0-hour contract now?
Yes and no. I love that
Yes and
answer.
no.
I hate that answer. The lawyer should have said that, should I? Yes and no.
Yeah.
So can you have it? Yes. But what the new laws that are coming in as well next year are that for 0 hours contract, if you work a set number of hours every week for a period of 12 weeks, then they can look at what that as a reference period is, and then say those should be your core hours. So they're trying to get set hours for 0 hours contracts, which obviously sounds, it's a conflict, doesn't make sense.
No.
I'm not sure. I'm sure the government are trying to ensure that people get paid for more work and there's consistent work, but actually sometimes they're on 0 hours contracts for a reason.
But it's abuse, isn't it? It's what's happened is employers have abused 0-hour contracts.
Yes, correct.
They'll put you on the same hours every week for 2 years.
Yep.
And then something will change in the business, Or perhaps an employee, they prefer to do that shift,
Yeah.
and they sub you out and put that one in, and all of a sudden you're down to 9 hours.
So now what they're going to have to do is rotate.
Yeah.
So after a period of that, before that 12-week period expires, they've got to not give shifts, get the next shift in. Presumably it's a bank of staff with 0 hours contract.
They've just got to be flexible. and
Correct.
move
So that's what I
around.
mean. It will still exist, but there are laws in place to stop that.
I mean, you could get an AI to produce the schedules that mix it up.
Yes, good.
But in some ways, isn't that just going to work to the detriment of the employee? Because they never know what they're doing 1 week to the next.
I mean, it depends on what they want. I mean, some people want 0 hours contracts. They want that flexibility. But yes, you're right. It's going to become problematic for employers where they want that service, and that's not what the law's going to allow for anymore.
But if you're on 0 hours, you still have all the same rights.
No, you don't.
No?
No, you don't. No. Again, they acquire it if
Yeah.
they have started to walk like a duck, talk like a duck.
Yeah.
And then they look like they're an employer, but that will only be after a period of time, because then you can see their pattern of conduct, that pattern of behaviour.
Same 16 hours every week in, week out.
Got it.
Then you get the rights.
Correct.
But on a 0 hour contract, what rights don't you get?
You
Let's
don't
say the employer follows it by the book,
Yeah.
and they mix it up, always varying it up and down, 9, 12, 16 hours, different days, Monday, Wednesday, Thursday, a few hours on a Saturday. So they followed it by the book. What employment rights does that employee not have?
Depending on how many hours they're working, they would have holiday rights, those sorts of things.
Okay.
But other than that, they won't have employment rights. They won't have unfair dismissal rights.
They can raise a
dismissal.
grievance?
They can raise a grievance. Workers can raise a grievance. That's
Yeah.
true, because they are protected by discrimination laws. So all those things still are still in
And
place.
they can be subject to a disciplinary,
They could be subject to a disciplinary as well. Correct. They could be subject to disciplinary.
but they don't get what?
They
The
don't
right
get
not to be unfairly
They
dismissed?
don't get unfair dismissal rights.
Wow.
They get protection for discrimination, those sorts of things. but
That's
nothing
it.
else. Yes, correct.
They're very limited.
Yes, correct.
So
And
if you're
that's
gig economy, if you're on the gig economy and you're, I mean, what about gig economy? I mean, I guess gig economy is just contractors.
correct. So
The letter of the law.
So all they're going to look at there is the contract. What do the terms state?
Yeah.
Is there a breach? What are the understanding of the parties? And everyone will just abide by those terms anyway.
And do you get involved in those sort of?
Very rarely, because contractor work doesn't end up in the employment tribunal, which is our bag,
Yeah.
or the employment appeal tribunal or court of appeal for our purposes. So we don't get contractors apart from in circumstances where they're arguing that they're employees.
Okay.
They've created like a sham company or that sort of thing.
And so sometimes when I talk to people, they use interchangeably wrongful dismissal and unfair dismissal. We've done a lot on unfair dismissal. What's wrongful dismissal
Yeah,
all
so
about?
they're not the same. They're not the same. So unfair dismissal means
Do you find that people use them interchangeably
They
as
do,
well? And it's
absolutely
like,
they do,
No, you're
absolutely.
talking about.
It's understandable, isn't it?
Is
It's
it?
a slight shit. Well, I was wrongfully dismissed and unfairly. Which one was it? So unfair dismissal means you've been fired unfairly. There's not been a fair reason, or there's not been a fair process. And at the moment, you have to have at least 2 years service for that. Wrongful dismissal means you haven't been paid your notice pay. So you can claim unfair dismissal after 2 years, but before that, if somebody gets fired for gross misconduct, you can still claim wrongful dismissal, because when you dismiss for gross misconduct, you don't get your notice period.
No.
So that's the only reason. I had a case of somebody just the other day, in fact, and I told them the juice wasn't worth the squeeze in terms of paying a lawyer to do it, because their daughter, who had worked for 6 weeks in a bar while it was at university, got fired for gross misconduct, but she was innocent, apparently giving a staff discount to somebody that wasn't a member of staff. Whether that's true or not doesn't matter. The point is, the maximum value of her claim is 1 week's pay. So she's going to claim wrongful dismissal. I spoke to her and her parents about how to do it without a lawyer. And, as I say, it's the principle of the thing, but, principles can be expensive if they're going to instruct somebody.
And how did they do it? Did they go, because you can still go county court or with wrongful.
So they're going through the employment tribunal.
Yeah.
So if it was talking to me, I would be saying you take it to the employment tribunal, as long as you're within your time limits, because the time limits in the county courts and the high courts are different, right?
Yeah, 6 years.
Yeah.
So would you do county court claims on that basis?
We don't.
We only deal with employment.
We specialise totally in employment law.
Okay.
If it goes into that realm, we have other lawyers that we recommend, like
Okay.
yourself.
Yeah. We'd like the county court. We're very comfortable with the county court.
Yeah.
Okay.
Even things like post-termination restrictions. So people that don't know.
Restrictive covenants.
Yeah, things that the employees can't do after they leave the workplace. Steal their clients.
We've just done a massive one in the motorsports industry.
Yes.
And it's been really interesting.
Yes. Tell me.
No, I can't tell you anymore.
Tell me what you can tell me.
No, because I'll end up getting a letter, but about breach of confidentiality or something.
Yeah.
But restrictive covenants.
Yeah, so I mean that's a big one. We get that
Yeah.
quite a lot. And whilst we won't take it to the court, a lot of 9 times out of 10 we can do one of those letters that will just put the wind up. the right to sail to make sure that they don't continue.
And
with
if anyone's now listening and they're thinking, okay, restrictive covenants, I've got them in my contract. What sort of things? Let's say it's an employee listening and they want them not to be enforceable.
Yep.
What sort of things can we tell them to look out for?
The quickest thing that will make them not enforceable is if they've got the entitlement to make a claim for constructive dismissal. Is the first thing I'll say.
Yeah.
So because constructive dismissal means there's been a fundamental breakdown of trust and confidence between the employer and the employee. So the employer's conduct has breached the employment relationship. Guess what? I'm no longer obligated to do the things under the contract, which means the restrictive covenants are gone. So that's one argument present.
Constructive unfair dismissal.
You got it.
We'll get them off their restrictive covenants.
You got it.
Right.
Again, we needed 2 years for that.
Yeah,
But
2 years, yeah.
Otherwise, there's certain elements that look at the reasonableness of restrictions. So how long is the restriction for? Typically, the longer the restriction is in relation to higher level employees or directors because they can do more damage.
So 12 months.
Say 12 months is the maximum normally.
12 months or a cleaner.
Cleaning might have 3 months. And they might have
What if they
nothing.
put 12 months in?
Then it won't be enforceable.
They're on hide into nothing.
Correct. So the length of time has to be measurable and reasonable and balanced. Typically, you're looking at 3 to 6 months unless it's a high level.
Okay.
Geographical area is also one. Maybe not so relevant now with people being working remotely and offline, online, so on and so forth. But if I wanted to set up, Tosh & Co. Solicitors would be a terrible name for a firm, but Tosh & Co. Solicitors, but for my former employers, and just down the road, well, in those days, people walking through the door, they know Tosh, they know I was working there, I could steal their business. So you might have a geographical restriction. And then there's restrictions of the type of things you do. The most important thing an employer would need to have in there is not just a non-solicitation, which means don't nick my clients, my suppliers, my staff, but it's also to have what's called a non-dealing clause. That's the biggest one. So non-dealing means somebody leaves and then a client who's very attracted to them because they did a great job when they were working with them, wants to go with them, you can't. The employee has to say, no, I can't, I've got a non-dealing clause.
Right.
If you breach that and you do steal your clients and they steal the clients and do breach the non-dealing, then the employer is entitled to sue that employee and any employer that they work for a breach of contract, and that means for any money that they've lost as a result of that breach.
But only if the new employer knew before they engaged them.
Correct. So you would say that they have
Knowledge.
They've conduced it.
Yeah.
So typically what happens is you write a letter to the employee, and then you write a letter to the new employer, copying in the letter that you sent to the employee, so there's no argument at all about the fact whether they have knowledge.
Yeah. And you say, Paul Britton was a client of mine, and he's taken it with him to your business, and that's a breach of this.
Yes, and I will ask them to do what's called an undertaking, which is like a legal promise. And if you break that legal promise, you can take it to the court.
Not to do business with me, or
so I would undertake. So if you're the employer, and my employee is left, taken a load of my clients and gone to you, I can write to him, and I can write to you, and I can say, look, if you don't know about it, this is what we think has happened. You give us a written undertaking to confirm this is not what's happened, as far as you're aware. If you don't get that, then we sue you. If we don't get it from them, we sue both. But the money would be the employer because typically those clients are going on to the new employer. Yeah,
for your losses and your damages.
Yes.
It's a complex world.
Sexy stuff, isn't it?
Who knew when they were tuning into this that they would be learning all this? Okay, really interesting other area, which also people say a lot when they're speaking to me. I've been victimized.
Yep.
I'm being victimized by my boss.
Yep.
But it doesn't mean what 9 out of 10 people I find thinks it means.
I would like to ask you what it means, but you know what it means.
I do, yeah. So you're the guest, so you've got to do it.
So typically the layperson, victimized means you're picking on me.
Yeah.
You victimized me. Yeah. You victimized me. You're picking on me. You're bullying me. But in law, victimization is in America, it's called retaliation law. So and you're retaliating normally for having done certain things. So that's the victimization. The certain things are
which you're entitled to do.
Yeah, sure. So I bring a claim as an employee of grievance for discrimination in the workplace. Yeah. Let's say, and then other members of staff start, treating me badly, making comments, ostracizing me, whatnot. That is victimization. So even if my claim, my grievance has no legs, if they victimize me, I've still got a claim to victimization. And victimization or retaliation is the same type of compensation as injury to feelings that we mentioned earlier for discrimination laws. So that means up to 60 grand.
Yeah.
So it's often the case employees will have a claim for discrimination. The findings aren't in their favor. They try and go back in the workplace. Everybody starts giving the cold shoulder, and then they want to start documenting those different acts of real victimization.
But there's a very narrow definition of it. So anyone that feels like they're being victimized, just like we were saying with ChatGPT earlier, whatever you think it is, fact check it,
Yes.
look into it a little bit more,
Yes.
make sure you understand it before you do the wrong thing and bring a
Absolutely.
victimisation
Absolutely.
claim.
And there's also a way to bring up claims for victimization. You have to bring it to the appropriate person in the workplace. So not just a case of just being victimized and saying nothing about it. Plus, you want to document these things. If you're going to pursue a claim in the tribunal, you don't want to just rock up and say, oh, this is what happened. You want to create the paper trail. And typically, the paper trail is created by going through a formal grievance process or whatnot. So it's really important that people do that, regardless of the fact that they probably think the decision's already been predetermined. There's no point doing crystal ball law. You have to go in there, go through the process, and then show this is what's actually happened.
So what would you say if anybody feels that they are having their employment rights breached or they're being treated in a way that isn't lawful? What would be the practical steps that you would give them?
They've got to talk to somebody like me. Got to talk to a solicitor, find out what their rights are, what their options are, what's open to them, and then map out what the next best steps are for them. Because when you're in that situation, you're at work, you're 9 to 5, let's say, Monday to Friday, you're spending more time with these people than you do with your friends and family. So you become isolated, you become a little bubble, and you start to not see your way out. And what I often see that manifests in people going off sick, work-related stress, then it builds up so much you can't go back to work. So they just need to talk to somebody. They just need to talk to an expert who knows what they're talking, whether it's an HR expert, solicitor like myself, who can then talk to you about, look, actually, there's a way out. This is what it looks like. Do you want to do those things? Or don't do any of that stuff, quit your job, get another job.
So early advice is a really good one.
Excuse me.
Early advice is a good one. What could they do whilst they're employed? What should they be doing?
So whilst they're employed, they should be raising a grievance about it. Grievance, people think it's got a bad name perhaps. Grievance isn't just a complaint. It's basically a help me letter. Can you help me with this? Can you help me with that? And the idea is you give the opportunity to the employer to fix it. So that's what they should do. They put it clearly. Now, not just a rant. You need to give it to them like they're watching a movie. What was said, what was done, where it was, details of any witnesses. The more information and evidence you can give, the better.
Yeah.
What they also should realise is you need to know the rule book in these situations to know what to win. I'm talking about like a case. And what I mean by the rule book is understanding that if you're playing a game of chess, don't use the rules of drafts. So what is the rule book? And the rule book is how evidence is looked at. So you definitely know, but most people know this from television. Criminal law, the burden of proof is beyond a reasonable doubt, right? So if I'm accused of murder, the evidence is to show beyond a reasonable doubt that I committed that act. If there's a reasonable doubt, I get off the hook or lesser charge, right?
If there's not, then you're not guilty.
Yeah,
not off the hook.
Maybe manslaughter, maybe instead of murder. So is what I was thinking. So whereas employment law is on a balance of probabilities,
Yes.
which in English means what does it look like? So that means not what is the truth. What does the evidence suggest has happened?
More likely than not.
Right. So what happens is employees go there with this moral compass and they're saying, this is right, this is what's happened to me, you've got to do something about it. But and it's going to sound horrible me saying this, the legal system doesn't care and neither does your employer. They want to say,
where's your evidence?
What does the evidence look like? Now, what a lot of employees will say is, well, it's only my word against theirs. That's okay. That's still okay. It's still going to be who's more plausible. I often do this thing with clients when I'm teaching them the balance of probabilities and I say, let's say the time is now 2:00 in the afternoon. I say, it's your word against mine, Paul. And you tell the judge, yep, it was, and you're not a solicitor in this fantasy scenario. You tell the judge, yes, I was talking to Tosh at 2 p.m., 2 in the afternoon. And I say, well, actually, I'm a solicitor of the senior courts and I never lie. It was 2 a.m. And then I say to my clients, so who do you think they believe in a balance of probabilities, even though you're telling the truth? And 9 times out of 10, they'll say you. And I said, why? I said, well, because you're a solicitor. I said, you ever heard of a dodgy solicitor before? Wow. Not that I am one. Yeah. And obviously seniority doesn't require honesty.
But it's compelling, no? Officer of the
compelling.
court.
Well, also, you then start to investigate it. Tosh, is your office open at 2:00 in the morning? Tell us the circumstances where that's happening. Now, whatever it is, it's a lie.
Yeah.
Now, the more details this person can give, what's more likely than not, the better. So don't be put off when it's one person. So when I see these situations where it's investigators, they do one person's word against it, we can't make a decision. Yes, you can. Yeah. You can make a decision on the balance of probabilities. That means eyeballing them, body language, what they're saying, how they're saying it. All those factors can be taken into account. Someone's reasonable. So that's the most, when you say what's the most important thing they can do, is not just do a grievance, but understand how to do it. Use the rule book. So
Evidence.
What have you got that will show that your version of events is more preferable than the alternative version? That applies for disciplinaries, grievances, everything.
Yeah, we call those documents independent documents, so independent of your witness statement.
Yeah.
So if it's a bank statement or in that case, the scenario you gave was a good telephone conversation. Well, who's got their telephone records?
Yep.
We had a big case in 2014, and it was a contractual dispute. It made all of the national papers. And the judge, when she was summing up, when we had won, said that our client was consistent in the text messages at the time, we'd evidenced all those, consistent in his pre-action letter from us to the other side, consistent in the pleadings, consistent in the negotiations, and consistent given oral evidence in court today, and therefore she preferred his evidence.
Yeah, there you go.
Whereas the other side, all over the place.
Yeah.
They kept changing the story to fit the facts. Every time we said, well, what about this? They changed their story a little bit, and there was an application to amend their particulars because they couldn't claim what they were doing when we had given them a bit of evidence to say, you were wrong. So it's the one that really can evidence that, I mean, my client was right. But in a lot of cases, it's just whoever can evidence their case the best is likely to get over the line.
Correct.
So I think the thing that you said about they turn up with a moral compass.
I think you're spot on there. And the evidence becomes, I mean, the majority of the cases we deal with, Paul, don't go to tribunal.
No.
Because, as I say, compromise is the cheapest lawyer, right?
Yeah.
And so that means, I mean, do you know what the statistics are for the number of cases that are settled? I'll get my teeth in. How the statistics are for the number of cases that get settled?
That settle?
Yeah.
No.
It's 85%.
85% of employment disputes settle.
And can you imagine that?
It's amazing.
The amount
right?
that don't have any substance.
Yeah.
So we don't get to the evidential stage, but there's just now enough browbeating.
Just get rid of them.
Yeah, just get rid of the problem. Let's go and make money rather than spending the time
defending
with this not making that money.
There's some clients will say it's the principle.
I agree. And then when they get a bill, that principle turns into a compromise.
They want their day in court.
Yeah, so I try and persuade them not to, because that's an emotive decision. It's not just a commercial smart decision. But sometimes employers need to send that message out to staff that we're not going to tolerate this. Yeah. And so that's also true.
And part of that evidence collecting, what would you say about covert recordings?
Yeah, I mean, it's interesting, isn't it? Because in employment tribunals, covert recordings are admissible in court. So if they bring up something that is of substance, so let's say they pick up some recording of some racist comments, for example.
Perfect.
Well, then it's perfect.
Yeah.
If they're going around recording everything everywhere and doing whatever, whatnot, now no people have any trust or anything, tribunals don't like it.
No.
Typically speaking, they don't like it. There's something called banking.
Yeah.
You see the same thing? Okay, so that means that they start downloading loads of documents before they go, and confidential documents and everything else. They want to protect their position. Well, again, if it shows something, that's one thing. If you're just doing it like a dump, well, actually, that's confidential information that's breaching GDPR rules and all sorts of other things, so which would be a dismissible offence. So if you're going to do it, make sure there's a really good reason, not just because you think something might happen. Is it probable or not?
Yeah.
And then disclose it, because otherwise, as part of disclosure, you'd have to disclose all of those recordings. And then you get a different picture, and then it looks very bad for you as an employee. So what do I think about it? I think, yes, do it. I wouldn't advise somebody to do it necessarily, but if there's something that they think it's worthwhile, it's admissible. If not, just don't. Why do you need to do that? Yeah.
We had a case where the employer had arranged an event at a bar, and for all their employees, it was clearly an employer-led event, and there was a sexual harassment that took place, and we were defending. Our client was being accused.
Yep.
And in this business, the individual refused to allow the CCTV operator, wouldn't give consent to disclose the CCTV of her at this event. So we said, well, we want it. But what we went for in the end was the CCTV operator at the third-party venue to do a written description of what they saw on the CCTV, and it was perfect.
Wow.
She dragged him to one side. She snogged him. He was never the aggressor. He was never the perpetrator of it. And so we didn't need the clip anymore because we had this great description. So there was no issue.
Yeah.
Their side dug their heels and said, absolutely not. He was, but we've got this description, and the tribunal never ordered disclosure. They never went for disclosure because they were the ones being difficult about it.
Yeah,
but we were just happy with this description from the operator, and we won that in the employment tribunal.
Yes.
Yes. It was just a great description. So we didn't need the clip because we had this description. And that's the point that you're making. If you've got a recording, shows nothing, great. I mean, if you say you made a comment and they say, yes, we did, well, you don't need it now. You don't need the recording because it's not an issue. They accept it. They've admitted it. You can just move on.
It's not my bag, but I think you can comment on it. And I appreciate the interview, but I'm going to put a question back to you, which is there's also a criminal liability.
Yeah, I mean, obviously, I mean, certain discrimination, inciting racial hatred, there's so many different criminal offences that can be committed. And actually, quite often we get employment cases where there is a big crossover between crime. But it all depends if, during the employment dispute, does someone want to turn the heat up and start getting the police involved? And we've also had cases where there's a criminal trial and an employment trial, and we stay the employment proceedings pending the outcome of the criminal proceedings,
Yes.
see if we get a guilty or not guilty.
Yeah.
Let's say we got a not guilty, which was good for us. It doesn't therefore follow that in a criminal court, that's belt and braces in a civil court.
No.
It's persuasive,
Yes.
but it's not binding. They can make a different determination over here.
Yes.
So when you start your employment, you've still
Yes.
got another battle on your hands.
Yeah,
and you
that's
might
right.
say, well, he was found not guilty in the criminal courts.
Yeah.
They can say, well, different burden of proof.
Yes. Yes.
We'll deal with it here.
So yes, I see a lot of that. I get clients that come to me. They've done the banking. They've put those things, and you've got to be a bit cautious about how you're
Faciliously
dealing with it.
downloading everything,
Yeah,
and
that's
recording
right.
everyone.
That's right.
But it can go against them.
It can go against them if it doesn't pick up anything.
So use it cautiously.
Correct.
I mean, Tosh, that's been excellent, and I'm sure there's a lot of listeners that's been really helpful for. We've had a few questions come in, so I'm going to read you them. They've come in on the phone, so here we go. So this one, I worked for a tech company in London and raised a formal complaint about my manager's bullying behaviour, shouting in meetings and belittling me in front of colleagues. A month later, I was put on a performance improvement plan and then dismissed for underperforming. The company says it's a coincidence that I feel that I was being bullied, but I feel that I've been punished for speaking up. Is there anything I can do?
So again, it's going to be fact sensitive, right? If somebody bullies me or discriminates against me, but then I get caught with my hand in the till, I'm going to get fired. It doesn't diminish the treatment I received earlier.
I mean, dishonesty.
Correct. So the first thing I would ask is, what's the bullying about? Is it because he doesn't like her? Or is it sex, race, religion? Is it protected characteristic things? And what is there to support that is the first thing I'd ask. Second thing, and obviously then the grievance needs to then be presented in such a way with the evidence on a balance of probabilities that we just discussed that shows why her version of what's happened is more likely than not. So I'd want to know what the company decided and how they came to those findings. What was the thinking behind it? In terms of the PIP, the Performance Improvement Plan, well, it's got to be justified, isn't it? So it's got to be documented. So what was the performance issue again? So they're two separate. And it might be a coincidence, or it might not. It will only become absolutely relevant when we look at the PIP in greater detail and see it just doesn't stand up. It's just
Well, if it was
nonsense.
ridiculous, the PIP.
Yeah, correct. If they've
So
just
let's
got
say you
no
worked there for
substance.
4 years, you've only ever seen 4 clients a day, and then they put you on a PIP where you've got to see 10.
Correct. Unless there's some
It was
real
engineered
reason. Yeah,
for you to
exactly. That's the
fail.
right word I was looking for, Paul.
Yeah.
It's clearly been engineered, then clearly it then becomes relevant to the earlier set of facts. But if not, then one is separate to the other. So what can she do about it? Again, is there any substance to the PIP? But more importantly, what was the bullying about? Because if we've shown that it was discriminatory, well, then that claim still stands. If it was just straight bullying, well, constructive dismissal is the same as unfair dismissal. So it means she can claim up to a year's pay, assuming she's got more than 2 years' service.
And if in doubt, early advice from a solicitor
Give me a shout.
during this process. Great. Okay, what have we got next? Okay, I run a small design agency with 15 employees. One of my senior team members have been underperforming for months, missing deadlines, poor attitude, and clients have been complaining. But every time I try to raise it informally, she hits that feeling bullied button and might make a complaint. What can I do?
First thing is, be very, very clear and direct with your staff about issues. Whether she feels bullied or not is irrelevant. She can bring that up as part of this process, is what I mean. So you don't get to deflect it. People go off sick often when there's a disciplinary. That doesn't mean you can't call them and find out what's going on, and then eventually, if they're not going to come back, you do the disciplinary without them. So employers need to also know that they have rights in these situations, and what they need to do is, so I don't know if you've ever seen the program, Paul, it's Super Nanny. You've seen that?
Okay, yes.
So employment law is Super Nanny, right? Super Nanny with
Naughty
Joe Frost.
step.
Yeah, Joe Frost. People don't know. Joe Frost goes into people's houses where the parents don't know how to control the kids, and what they do is they misbehave and they sit on the naughty step. And the number of minutes they sit on the naughty step is equivalent to how old they are. So employment law is 3 naughty steps and you're out of the house. And the idea of the naughty step is to be clear what the standards are, the expectations are, and what the consequences will be if you don't continue to meet the standards and expectations.
Yeah.
So if I've got very clear issues with this employee, of whatever the situation is, she can bring up anything she like. I've got a disability. This is the issue. I feel I've been bullied. I'm not saying you're not going to be regarded or considered. Sorry, I am saying that it's not quite relevant yet because we've got this employer has an issue that needs to be dealt with, and they've got the right to get the employee to address those things.
Complaints from clients, missed deadlines.
Exactly right. So then when we do that, and if we say, well, I'm feeling being bullied, and that's why I'm missing these things, well, that's a different matter that needs to be it in bigger depth. Right now, that employer should have a very direct conversation. I'm not saying anything aggressive, but just like, this is what's happening. And if they're saying I'm being bullied, well, how are we addressing these deadlines? Why is that happening? Then we can talk about your other things. Work stuff first, then what their issue is.
Yeah, and if they say, why are you missing these deadlines, and they say, well, it's because you're bullying me.
Okay. The sentence enough isn't alone, is it?
No.
So what? How is that affecting that? What is the bullying you're talking about?
So dig
what
deeper.
So you dig deep to the nth degree, and then you find out whether there's bullying or not, and then depending on what the circumstances are, you're either going to part your ways, depending on the length of service, in the examples I've given, or you might even come to an agreement to part ways under a settlement agreement.
And in that sort of conversation that you're having, face-to-face?
Yes.
And would you advise a note taker, or if you were advising, in this case, the employer, would you advise a note taker or mutual consent to record the meeting?
Any is fine. Typically, I try not to get the recordings because it has to be transcribed. It takes more time.
Yeah.
So you have a note taker. It can be the person doing the meeting, unless it's a disciplinary meeting. But an initial investigative discussion can just be two people. We don't need to have somebody in the room every single time.
No.
Why do we need somebody else? It's when they say, well, I never said that. I never said this. Well, we're only in the first meeting. That can be, okay, well, I'm saying it to you now.
Yeah,
And
okay.
So you can correct it before it gets to a disciplinary.
Okay. And if there was lots of disputes over what was being said,
Yeah.
would you say, right, let's have the meeting again, but this time we'll have a proper note taker in,
Sure.
if it was just the two of you?
Exactly right.
Yeah.
Okay. Typically, there isn't so much stuff about what was said in terms of, they're normally accusing the employee of something and the employee's defending something in the initial meeting. So how much difference is there going to be said about certain things? But actually, it's normally the employer that misses certain things. The employee says, well, you said this and I said this in the meeting and I want that corrected. So yes, if we have an initial meeting, there's some doubt, rather than repeating the meeting, I would rather save the client time. You go to the disciplinary anyway, or the performance plan, and you record that meeting and then address it there and then.
But the salient point is, don't shy away from it if you're the employer.
Yes.
You've got to have that conversation. You've got to have an adult conversation.
Yeah.
If they don't like the confrontation, which we've mentioned a few times, can you get a third party in?
Absolutely. That's what we do.
Yeah.
So sometimes clients engage us to actually terminate the employee's employment because they don't want to do it.
Or just have that difficult conversation about
Correct.
performance.
Managing difficult conversations is a good skill that we as lawyers have.
Yeah.
We get quite comfortable with it, quite frankly. So you can have an HR person. Typically, a lot of companies will have that, and they will just speak to the employee about what the issue is and do it that way. It's not a problem. Or you can get somebody to train you to do it like I do.
So another one, Tosh, my company has been running diversity training sessions after some complaints about inappropriate jokes and WhatsApp messages. One of the senior partners says, everyone's too easily offended and refuses to attend the training. So the senior partner is refusing to attend the training. He's saying everyone's too easily offended, calling it political correctness. What should I do?
So the senior partner can do as he wishes.
Yeah.
Like anything, though, there are consequences. So there's a difference between our attitudes at work and what the law might say about it. So the law says that you have protection for that sort of derogatory comments. If it's the one-off comments, you might be in the lower vento bands that we discussed earlier. It's more serious things that, But
you still got protection.
You still got protection, correct. So if the employer refuses to put training in place, that means there's two things. There's something called vicarious liability. So when you sue for discrimination in the workplace, you can sue the individual as well as the employer, unless the employer has taken steps to stop that from happening.
Like the training in this scenario.
Exactly right.
But he's refused to take it.
He's refused to take it. I mean, he's already on the hook then for a discrimination claim if that's happened, because he hasn't trained his staff. Stupidly, you would say, I suppose, is that, employees know what to do. You know what not to harass, discriminate, or whatnot. But sometimes, maybe it's tongue-in-cheek, the word banter is used. And banter's fine. This is not the thought police. You can use banter with your mates and where it's in your own closed circles. But just know you can't use that kind of language in the workplace unless it's a safe place for everybody. And if it's not, it only takes one person to get offended one time, even though they were joking with it all the way along for weeks and weeks, and they decide, I've had enough of this. I think that's racist or sexist or whatnot. And that's what it takes. Whereas if you've got the training in place, then the employees, the way the courts call it, they're a frolic of their own. So that, they've done it on their own. I've done everything I could do, Judge. What else do you want me to do? So the owner there would be silly not to put something in place that's very reasonable. And if he doesn't want to go on that training, well, I mean, as long as he doesn't discriminate or anything like that, then that's not an issue. He doesn't.
So they could joke about the same thing, joke for 12 months, and then one day the employee turns around and says, that's not funny anymore.
Correct, because there's a very common that people will just be quiet because they don't want to rock the boat.
Yeah, and there's no defence to say, You know,
Well,
he thought it was
defense.
funny.
There's a defense in terms
We
of
put training in
how
place.
it's an objective and a subjective test.
Yeah.
Were you subjectively offended? Well, yes, I was or I wasn't.
Mm.
Were you objectively offended? Well, would a reasonable person be offended? So if you've got a whole pattern of people, them engaging it, maybe the response from that person who's now offended has been quite, virile as well.
Yeah.
Well, then in reality, it's going to be, oh, come on,
Yeah.
really?
Yeah.
found
Or you
that
were as
offended
bad
now?
and
How
you-
about what about
yeah.
you? So that's what
They
the evidence is looking at.
participated and
Correct.
made counter jokes,
Yes.
encouraged that form of banter,
Yes.
and then all of a sudden they turn. So the objective test could save them if they've gone along with it and the other one had participated.
Correct.
Great.
Correct.
Thank you, Tosh, for coming on Is That Legal today and talking about everything that's employment and legal.
Thank you for having me, Paul. Absolute joy. I'd like to be asked again if we can do this
Yes,
again.
well, we've got to do a catch-up in April, haven't we,
Yeah,
when
love
these
to,
new
love to.
rules come out.
Thank you again.
We hope you've enjoyed today's episode of Is That Legal? Remember to subscribe and hit the bell if you would like to know when our next episodes are out. And that's all for today.